Hello, my name is Deirdre Wheatley-Liss. I am an estate planning attorney and I practice in New York and New Jersey. Given everything that's going on with the pandemic, the stay at home, and the new normal, we've been receiving a lot of questions from clients. Is their estate plan correct? Is it up to date? Is there anything that they need to do? A lot of people don't have an estate plan, or they have an estate plan that they haven't looked at in a while. What I'm hoping to do today is to bring to you some questions that you should be looking at for your estate plan so that you can know either it's current and correct, it needs to be updated, and here are the action items that you can take. And it's something that instead of being a stressor in your life, is something that you can take action to be able to complete. When we're looking at estate planning, the first question that we really need to think about is, who is your family? When you're thinking about your family, who's the plan for? Who are you trying to protect? Who do you want to have security if you're not here anymore? For some people, it could be your spouse. For others, your spouse and your children. Maybe you have grandchildren. You want to make sure that they can go to college, give them some funds to launch them to adulthood. For many people these days, it's their parents. They want to make sure that their parents have enough financial security during their retirement. Perhaps it's your siblings. Maybe there's a family property that you want to make sure stays within your family. Pets, our fur babies. Who's going to take care of them, and how do you offset the cost of care? Not everybody who is in a family unit is married to each other. Who are your partners that you want to make sure to protect? Separately from your life partner, do you have business partners that you have obligations to that you need to make sure are considered should something happen to you? What about your friends? What about doing something fun? I had a client one time, in his documents, he left $5,000 to his college roommates with the instructions that they had to take a trip to Vegas in his honor. Potentially your community. That could be charities, that could be your alma mater, houses of worship, whatever it is that's important to you. Below here, you're going to see that I have a list called action items. And one of those is to do a list of all of your family members. Who are the people that you would be thinking about when you're thinking about with your estate plan? So if we know who your family is, we know who we're planning for. What are we planning around? These are your assets. These are the things that you either own now or would come to fruition if you passed away, that are available to go to somebody else. Personal property, that's the stuff that's in your house. That may not have a lot of monetary value, but it could have huge value for your family members, collections that you have, photographs that you have, artwork that you've collected on vacations together. Your vehicles, that could be things like your car, trucks, any kind of watercraft vehicle that you have, anything that you can utilize to move around. Real estate, your primary residence. You may have a vacation residence. You may have either full or partial ownership of an investment property somewhere, a business property somewhere. Your bank accounts. Now, these could be bank accounts that are in joint name or bank accounts that are only in your own name. Checking accounts, savings accounts, CDs. Investment accounts. With your investments, consider brokerage accounts that you have, but also consider, your safety deposit box. You maybe have some stock certificates still in there, potentially savings bonds that are in there. Your retirement accounts. This would be a 401k, maybe a 403b if you work for an educational institution or for a state government. Your IRA that you have. Life insurance. And I want to do a pause here on life insurance because I am recording this during the COVID pandemic. A lot of insurance companies are offering touchless life insurance applications right now, which means that they are expedited life insurance applications. That would mean, I was speaking to a colleague of mine, that they are able to take applications and get insurance in place in 48 hours to a week, $1 million, $2 million, $3 million, not going through what was the normal process and procedure prior to the COVID pandemic. So something to keep in mind if you feel that you need additional insurance within your estate plan. Do you own a business? Do you have an LLC? Do you have a corporation? What is the potential value of that business, and what are the liabilities of that business? Employee benefits. Sometimes people, there's a lot more benefits that are available to them through their office than just their salary. You could have stock options. You could have life insurance that's provided to you as an employee benefit, health savings accounts. If you aren't sure exactly what all of those are, you can contact your HR representative and get a list of those. And then finally, digital assets. These sort of fall into two categories. One are like your personal property, your life assets, your Facebook page, your photographs that you have saved somewhere, your blog that you started. Who could manage those and get access to those? Those are the valuable things for your family members. You also have digital assets in the way that you've got digital accounts. You may have some accounts that you have no paper access to. And you need to make sure not only to record those, but that somebody actually knows where they are. An action item relevant to your assets is you have to have a list of all of your assets as you're starting your estate plan. So one that I found that you might want to look at is, there's a link below, is Schwab has a asset inventory. It's free. You don't even have to give them their email to be able to look at it. But it's a comprehensive list of assets that you could then download to be able to make a list of what your own assets are. And the link is below the video. So now that we know who you're planning for and we know what you're planning with, do you have the key documents in place? Any complete estate plan has to have at least 3 documents. The first document is a last will and testament. Your will is a document that says, if I die, these are the people who get the assets that are in my own name. It does not control joint assets, and assets that do not have a beneficiary designation. In your will, you might leave assets in trust for somebody until they reach a certain age, or for asset protection purposes. You would name an executor, the person who's in charge of making decisions in your will for what it is that they're going to do. The next document that you have to have is a general durable power of attorney. A power of attorney allows somebody else to make financial decisions for you while you are still alive. The final document is a healthcare power of attorney, sometimes called an advance directive or a living will. A living will is a document that allows somebody else to make medical decisions for you while you are alive. Those 3 documents are the foundation of every estate plan, and you need to have all 3 of them. Now, your estate plan may contain additional documents. You could have a revocable trust. A revocable trust is something we consider to be a will substitute. So instead of your will saying, I leave XYZ to ABC people, your will would only say, I leave everything to my revocable trust, and my revocable trust then leaves XYZ to ABC people. Revocable trusts are more or less popular depending on what state that you live in. They're a way to reduce probate costs if you live in a state with a high cost of probate. In New Jersey, we have a low cost of probate. Or if you have assets out of state, like you have real estate in another jurisdiction. So some of you may have that, some of you may not. It's right for some people, and it's not necessary for others. The last one is an irrevocable trust. Now, an irrevocable trust is one that you would have set up that when you set it up, you no longer have control over the trust. Maybe you made a gift into this trust. Maybe it owns life insurance. Maybe you set up the trust for tax planning purposes. In looking at as if your estate plan is complete, your action item is to gather up all the documents that you have right now, if you have them. Your will, your power of attorney, your healthcare power, any trust, revocable or irrevocable, and actually sit down and read them. Now, you may find that when you read them, they aren't as understandable as you would like them to be. If that's the case, no problem. Give a call to the attorney who drafted them and say, hey, I need to review these documents with you. I need to understand in plain English what it is that these documents are. Once we look at your estate plan, it's not enough just to have one. You need to have an estate plan that fits who you are now. When you did that will 7 years ago, you were potentially a different person. You may not have had the same number of children that you have right now. You may not have lived in the same state. You could have been married or divorced since that point in time. A will is done to reflect who you are at that moment. And while attorneys draft them with great flexibility for unanticipated or even anticipated changes in life, the fact of the matter is you're not the same person that you were 7 years ago. So just like maybe a jacket that you bought 7 years ago that's sitting in your closet, the jacket's still going to keep you warm. It's still going to function, but it's not necessarily what you would purchase right now. And it may not fit you as well as it did 7 years ago. Some other questions to ask for if your estate plan is current. Did you move locations? Have you changed jobs? Again, all of those employee benefits, they may need to be re-coordinated with your assets. Have there been changes in your family? Do you have additional children or grandchildren? Has somebody passed away? Do you have changes in your fiduciary? Do you still want your sister to be the guardian for your children? Or do you want to name your brother-in-law instead? So in looking at the documents and reading them, is there anything that produces a question or a point of friction for you? If there is, make a note of it because that's an area that should be changed within the documents. Now, I've mentioned the concept of trust a couple of times, and I just want to take a pause here and explain what a trust is because not everybody is familiar with it. I think that the best way to think about a trust is to consider it to be a mini family business. Think of the local pizza restaurant, the family pizza restaurant that you frequent, okay? That restaurant is a company that is separate from the family, but it is run by the family for the benefit of the family, and a trust is like that. A trust has three parties to it. The first is going to be the founder. This is the person who creates the trust. We call that a grantor. The second is going to be the person who's in charge of the trust, the president. We call that person for a trust, the trustee. And then finally, the beneficiaries are like the shareholders, if you think of the family business analogy. They're the ones that can benefit and the only ones that can benefit from the trust. And a trust can own anything that you can own. It could have cash, real estate, stocks, bonds, businesses, whatever the case may be. The single most important aspect of a trust, though, is that it allows there the opportunity to both provide guidance and then tax reduction and asset protection. So what do I mean by guidance? Well, let's say that your beneficiaries are 8, 12, and 15. First of all, they can't legally inherit money because they're not over the age of 18. But secondly, the age of 18 is probably not the best time for people to be getting large sums of money. So a trust can create something where you name somebody else, maybe one of your siblings or a parent as the trustee, so they can provide guidance to the children and provide the money, make it available for them, but not have it handed over to them until they get a bit more financially mature. Often for people, we use trust also for tax reduction. You can use a trust to reduce income taxes, to reduce estate taxes. But the big one with trust, and the one I want to focus on a little bit, is asset protection. If you create a trust with your money, and that trust is for one of your family members and for a loved one, the trust can be designed in such a way that it has complete asset protection. What do I mean by that? I mean that if a beneficiary finds themselves getting divorced, or they find themselves potentially facing bankruptcy because of an unexpected global pandemic, or they start a business and the business fails, or they're sued for any reason whatsoever, the assets that you leave to them in a properly drafted trust cannot be used to satisfy the creditors of the beneficiary. This is of key importance because it means that the inheritance that you leave to your family can be left to them so that it provides a lifetime of security for them. If you left the exact same assets to them, not in a trust, and any of those things that I mentioned happened, there's a risk that the money is getting reduced or lost, and it won't be there to provide security for your family. I'd recommend to all of our clients that their default inheritance planning be a trust for their loved ones, so that if something unexpected happens in the future, the money would be protected from those unexpected circumstances. Another action that we need to do when we're looking at our estate plan is your fiduciaries. So who are fiduciaries? Fiduciaries are the people that are carrying out your plan. You can have the best written plan in the entire world, but if you don't have a person who's carrying out that plan, a person who recognizes and respects your values, then the plan just simply isn't going to be carried out the way that you want it to be carried out. There's multiple roles of fiduciaries for you to consider. The first one is an executor. The executor is the person who's in charge of your will. They have what I call a temp job. Their job is to gather up all the assets, pay off any taxes, debts, or liabilities, and distribute the assets to the beneficiaries, whether those be individuals, whether that be a charity, or if that be the trust that we talked about that you created. The trustee is a similar job, but it's a longer term job. The trustee's long term job is to manage and distribute the assets for the benefit of the beneficiaries. That means they need to sit down with the beneficiaries, find out what their needs are, maybe do a budget each year with them so that the trust can be used to support them and maybe support them in the way that you would support them. The beneficiary may come to the trustee and say, I absolutely must have the latest Tesla that's on the market. And you may look as a trustee and say, you know what, the person who set up this trust, they absolutely would want to support you having a car, but maybe not the $75,000 model, to have those conversations. A guardian is the person who's going to take care of your children who are under the age of 18. Sometimes the guardian is also going to be a trustee or sometimes a co-trustee. Sometimes family members will say, well, if the wife's sister is going to be guardian, then maybe the husband's brother would be a co-trustee with her, so that both sides of the family, that all of their values are being incorporated into the thinking about not only how the children are being raised, but how the funds that are available for them can be used for their benefit. The attorney, in fact, is the person under the power of attorney who would make financial decisions for you if you don't have the ability to make them for yourself. Similarly, a healthcare representative is the person who's going to make medical decisions for you if you can't make them for yourself. And very importantly, whoever you name in these roles, you have to name successors in these roles. You don't know if the person will have the capability to act in the role at the point in time in the future in which you need them to act. What you don't want is a judge trying to make a decision as to who your successors should be. You want to be the person who's making that decision. As an action item, you should create a list if you have current documents of who your current fiduciaries are and consider, should they still be in those roles? If you're creating an estate plan for the first time, make a list of the people who you think would best fit into these roles. And when you're making the list, keep in mind that somebody's going to need to get in touch with them in the future, so you should have their address, their cell phone, their relationship to you, their email, the best way to be able to contact them. So if you're looking at your documents and you have them, what is a quick checkup that we can do to make sure that your documents still fit you appropriately today? I'm just going to go down this list. First of all, do you know where the original is? Do you know where copies are? Do you have a copy if you don't have the original? And if you only have the original, where is a copy? Has your will been updated or revocable trust if you have one recently for tax planning? Just by way of background, for example, New Jersey eliminated its estate tax in 2018. So if you have a will that is planning that is structured for the New Jersey estate tax and there's not a New Jersey estate tax, that planning structure may no longer fit with what your goals are. Additionally, the Congress passed the Secure Act effective 2020. The Secure Act changes how retirement accounts are inherited by non-spousal beneficiaries. The documents that you have, if they were drafted before 2020, may not have appropriate language to address those assets potentially being inherited in trust, particularly if you have minor beneficiaries. Have you made any specific bequest? A specific bequest is I give a thing to somebody or I give an amount of money to somebody, okay? Markets go up, markets go down. Maybe you made a specific bequest of $10,000 to your alma mater. Your finances have changed and now you want to change it to $50,000. Well, maybe you want to leave them $100,000, but you don't want to have that be more than 10% of your estate. Those changes can be made. The specific bequest could also be of an item. I leave my shore house to such and such. If you're going to be leaving your shore house to the person, is that still the person to get the shore house? Well, what if you took out a mortgage on the shore house in the meantime? Are you leaving them the mortgage as well? Do they have the ability to pay it? Review those bequests and see if they still make sense today in 2020. Have you planned for your pets at all? Should something happen to you, they need to be cared for. Who would be the right person to care for them? And do you want to provide some money to potentially offset the cost of care of your pets over their lifetimes? Look at any trust that you have in the distribution terms and do they make sense? Going back to what I talked about before, the benefit of trust is asset protection, but if the trust is forced to terminate at a certain time, that asset protection is lost. So if your trust says, for example, I leave my assets in trust for my children, to have to be distributed at 25 and have to be distributed at 30, maybe consider if that still makes sense. Potentially you change that trust distribution and say, I leave the assets in trust for my children for their lifetimes. I name them as a co-trustee at age 25 so that they're making decisions with someone else who can pass along knowledge, information, and values before they have total control over the assets. And then at age 30, I name the child as sole trustee of their own trust. Again, look at your executor, your guardian, and your trustee. Your executor could be one or two people. I don't recommend that you have more than two people in the role of executor. Look at your guardian. Again, the guardian you had for your children when they were toddlers in an elementary school may not be the same people that are appropriate if they're in high school, particularly if it's important to you that they complete their high school career where they are. So you're maybe looking at a guardian moving into your house if something happened. And look at the trustee. Again, it can be one or two people who are doing that. And consider the concept of, if you're going to have a long-term, a lifetime trust for the children, a mechanism for them to be able to become the trustee at some point in the future. Now, your will does not control all of your assets. Again, as I said in the beginning, your will would only control assets that are in your sole name, not joint, and that do not have beneficiary designations. Non-probate assets are joint assets. When person A dies, if they're owned jointly with rights of survivorship, they pass to person B. Insurance. With insurance, you're going to have named a beneficiary of what those assets are. Same thing with your retirement accounts, or you may have pay on death accounts. In the event that something happens to me, this account is transferred automatically to XYZ person. As part of doing a checkup, take a look at those joint assets. Is it really your intention that they pass to the joint owner? Between spouses, the answer is usually yes. But sometimes I have older adults that have lost their spouses or are divorced, and they name one of their children as a joint owner on an account for convenience purposes, so the child can write checks. The issue is that when the older person passes away, that joint account does not get divided amongst the three children the way the will says. It only goes to the one child. And while you may have the best of intentions that the child is going to use and divide that money equally, I can tell you from my lengthy career as an attorney that that does not always happen. So if your goal is to have somebody be able to help you write checks on an account, maybe you make them a power of attorney over that account with the banking institution instead of making it a joint account. And that way, whatever's left over when you pass away goes through your will and would be divided, in my example, among the three beneficiaries. Your beneficiary designations of your insurance and your retirement accounts, along with asset protection, this is another key takeaway point. If your beneficiary designation says, I leave everything to my spouse and then to my two children, and your two children are under the age of 18, well, what happens when they turn 18? It's not going to go into that beautiful trust that you created in your will. Your two kids are going to have their hot little hands on that money when they turn 18, which is not necessarily the best time from a financial maturity standpoint for somebody to be receiving a significant amount of money. An 18-year-old hasn't had work experience. They haven't had to live on their own at this point in time. And it's not that they're not intelligent, it's just that they don't have the world experience to necessarily be able to make good long-term decisions. So if you've created a trust for your children in the will, what you need to do then is to change your beneficiary designation to say, I leave everything to my spouse, but if my spouse doesn't survive me, it goes to the trust for my children in my will, not to my children outright. That's really the most important thing, particularly if you've changed jobs, because when you filled out that entire stack of paperwork, chances are you weren't thinking about how to coordinate it with your estate plan as you were trying to get started with your new job. Power of attorney. Checkup tips for that. First of all, is your power of attorney durable? Does it say in there somewhere, my power of attorney is not affected by my incapacity? In a strange twist of law, unless your power of attorney says that it's durable, it becomes ineffective should you become incapacitated, which is pretty much the exact time that you need to have a power of attorney. If you don't have a power of attorney and you become incapacitated, then somebody would need to apply to the court for a guardianship on your behalf. This is lengthy, it's expensive, it's public, it is absolutely to be avoided, and a power of attorney will avoid that. Does your power of attorney contain gifting powers? Yes or no? Does it say that the attorney, in fact, has the right to make gifts? Should you have gifting powers? For some people, it makes sense. Yeah, I want my spouse to be able to do anything with my money that I could do, including giving it away, particularly if I'm older and maybe I'm concerned about asset protection planning from long-term healthcare cost. Or you could have an estate plan and say, no, I want this to happen exactly the way that it happens. And if somebody else has the ability to make gifts, they could disrupt that estate plan. So see if there are gifting powers. Who are the gifting powers to? Who can gifts be made to? And are there any limitations on those gifts? You can only gift up to a certain amount of money. If so, does that make sense still today? Or are there no limitations? In which case, does that make sense for your family situation? Who is your attorney, in fact? Is their address and contact information in the document so that if the document's needed, somebody can reach out to your attorney, in fact? Does it include their cell phone and their email number? Has your attorney, in fact, been notarized? In New York and in New Jersey, at least, because those are the states that I practice in, an attorney, in fact, a power of attorney must be notarized to be effective. If your power of attorney is not notarized, then it is not going to be an effective document. What about a checkup of your healthcare power? Now, your healthcare power could be in one document or it could be in 3 separate documents that I'm going to go over. One either document or part of your healthcare proxy is going to be a living will. A living will is a statement of your desires in the event that there is critical or end-of-life care decisions that need to be made. Again, the COVID crisis has really brought this forward, and it's resonating with people. I need to have a plan in place if my loved ones need to be able to make decisions for me. Look at your document. In many documents, it says, I do not wish to be put on a ventilator. Not thinking about the COVID crisis, but thinking about other end-of-life care situations where people didn't want to be, quote unquote, hooked up to machines. Obviously, in this situation, you would want to be put on a ventilator because that's oftentimes necessary with the COVID crisis for you to be able to survive it. So take a look at what that language is that's there. Look at who your healthcare representative is. And with the healthcare representative, unlike some of the other fiduciaries, you can only name one person at a time. I do recommend that you consider naming somebody who potentially is physically closer to you because they're going to need to be interacting with people at hospitals, medical people, things such as those, potentially going with you, seeing you there. And it's just something that's easier to do if somebody is local, again, all things being equal in the person that you name. The third aspect is a HIPAA authorization. HIPAA is the health privacy law so that no one else can get access to your personal medical information, which is great, except for if somebody needs to help make medical decisions for you, they obviously need access to that information to be able to make good decisions. So you need to name at least your healthcare representative to have access to that type of information. And sometimes older adults will name, for example, one child as their healthcare representative, but say that all of the children could receive medical information as they're all involved in their care. A couple of additional points if you have minor children. The guardians in your will. These are the people that if you pass away will raise your children. Give consideration to who in your life most closely matches your values for how it is that you want to have your children raised. This may not be family members, and that's perfectly fine. The most important thing here is that your children grow up the way that you want them to grow up. That could be that, again, you want them to stay in your community here, that you have a close college friend who your kids have known each other for years, and that's who you want it to be. That's who you should consider for the guardian. If you're concerned that I don't have all the family members involved in the guardianship, fine. Involve other family members in the estate plan by maybe naming them as a co-trustee. Something that's really come to light in the COVID situation is the concept of a temporary guardian. Should something happen to you and you can't get home and you've got a 5-year-old and a 7-year-old at home, you get ill, the EMTs are called and there's no relative of theirs that's there, they can't just leave your kids, your 5 and 7-year-old in the house, and they can't just leave them with your neighbor, even if your neighbor said this is what she would have wanted to have happened. You need to actually give your neighbor authority to act as an emergency temporary guardian for your children. This has become so much more important because right now, with travel being as limited as it is, your family members may not be able to arrive right away if something happened. And in that case, the police would have no other choice other than to somehow put your children into care if there wasn't a family member or somebody who was named as their temporary guardian to do that. So with the temporary guardian, think of somebody local who would be able to make decisions and care for your child until something could get sorted out on a more permanent basis. And then finally, with the trust for the children, as I mentioned, you have to have trust for your kids if they're under 18 because they can't take hold of assets. You should have trust for them even after the age of 18 to give them an opportunity to get life experience before money is handed over to them. And with your trust, what I would suggest to you that the idea of a trust is not just to pass along money, but to pass along knowledge and values. And that's where potentially having that co-trustee mechanism would allow that to make sense and would allow your children, when they do have full control over the money, to have the knowledge of how to actually invest, manage, and budget the money, and to know what your values are as to how you would like to have seen the money being used. On the other side of the equation, some folks are concerned about long-term care costs, and they absolutely should be concerned about them. It's expensive to need assistance with care as you get older in this country. Medicare will pay for your health and hospitalization. Medicare does not pay if you need assistance with activities of daily living, maybe assistance dressing, eating, moving around, taking medication. This certainly comes to light with people who have long-term degenerative diseases, Alzheimer's, dementia, Parkinson's, people who are suffering and need assistance because of cancer treatments, whatever the case may be. The way that you're going to be paying for those is, generally speaking, private pay or long-term care insurance. And private pay can eat into your assets very, very quickly. The median monthly cost of let's say somebody come into your house in New Jersey in 2019 was $4,767 a month. Assisted living, the base median cost, this is not the add-ons that you need if somebody needs assistance with the memory care unit or something of the like, $6,400 a month. Nursing homes, $11,650 a month. Again, a base median number. With those numbers, you can outstrip your assets very, very quickly, even if you've comfortably saved for retirement. Some people address this because they purchase long-term care insurance. Long-term care insurance is there to help offset the cost of care. If you don't have it and you think that it's something that should be part of your overall estate plan, speak to your insurance advisor about it. For people who run out of money, there is a safety net. Medicaid is there as a safety net. Unlike Medicare, Medicaid will pay for the cost of long-term care. However, to do it, you need to qualify financially. You need to be really, really poor. In New Jersey, you can't have more than $2,000 worth of assets to be able to qualify for Medicaid. And that means then, for example, if one spouse is qualifying for Medicaid, what's happening to the other spouse? How are they having sufficient security? Because of that, many older adults, they engage in asset protection planning. So asset protection planning is the concept of setting aside assets that the older adult doesn't have access to, but provide a security net for the family in the event that these long-term care costs are incurred by the family, and they're incurred over an extensive period of time, so that there's additional funds that are there that would potentially be able to support the children in the event that the parents run out of money to be able to pay for their long-term care costs. So what are some practical points that you should think about as we wrap up looking at your estate plan? And again, I have an action list below for you to look at, but put together a list of your assets and your liabilities. Similarly, prepare a list of who your advisors are, your attorney, your accountant, your financial advisor, your insurance advisors. So that if something happens to you, somebody knows who might have information about these things. Prepare a list of contact information for all of your fiduciaries, including current contact, email, cell phone, not just their addresses, so that you got to send them a letter. I want to focus a moment on passwords. In today's day and age, so many people, your assets are all back behind. They're all digital. You do all your banking online, all of your investing online. Something happened to you and nobody has your passwords, nobody has access to those accounts. I do recommend that you consider a password manager, something like Dashlane, that would allow, you just need to remember one master password, and then all of the other passwords are in the application. First of all, it's easier for you, so you're not trying to remember 150 different password combinations that you have. It's more secure for you because you can literally have a separate password for every single application that you have. And it's a way that if you would share that master password with your trusted fiduciary individual, your spouse, your adult child, whatever the case may be, that they would then have the ability to get access to those accounts should something happen to you. And then finally, where are those key documents that you have? Does somebody know where they are? I've worked with families for many, many years now. People have a variety of different filing systems, from they're actually in the file somewhere, they're in the safe deposit box, to they're in this particular drawer in the living room of the house, to they're in this, this unmarked black bag up in the attic. Whatever your filing methodology is fine. Just make sure that somebody actually knows where those documents are to find them. And then the last point that I want to make is going back to the idea that an estate plan isn't just about who gets your money. And that's really actually the least of it. When you're preparing an estate plan, it's about providing security for your family, and it's about passing values to your family at the same time that you're passing money to your family. Difficult conversations to have. End of life wishes. This is a perfect opportunity because of the present news environment to have a frank discussion with your family members about what kind of care you would want in the event of a terminal medical situation. Obviously, it's not a positive and easy conversation to have, but consider that you're the person who's making the decisions for your mother. On one hand, your voice as a daughter is screaming in your head, I can't believe I'm in this situation. I don't want anything to happen to my mom. I don't want her to go. And on the other hand, you're trying to think for what your mom would want. But if your mom's never told you what she wants, how are you going to know exactly the best way to honor her wishes? It's a conversation that you need to have. And this is an opportunity in the current global situation to have that conversation. Consider preparing a family love letter. What is a family love letter? It's nothing to do with the money. It has to do with all the other things that you wish that people would do. Asking your family to go on a giant family vacation, or rent 4 beach houses together, every other year. What are your hopes and goals for your children? Songs would you like them to play at the wedding that maybe you played at your wedding? Um, are there family recipes that you want to pass down so everybody can share the Thanksgiving side dish that you're always known for? What are the important things to you that are going to be memories for your family to have? Education, philanthropy, religious values, learning a different language, whatever's important to you, take the opportunity. And again, I've helped, hundreds and hundreds of families administering estates. The money's great. Nobody's going to say, really, no, don't give me the money. But they miss you. And if you can give a piece of you as part of your estate plan, I think it'd be the most valuable gift that you can do. And then the final piece to look at is trustee and guardian guidance. And this, again, is for people who potentially either have minor children, maybe you have a special needs child, maybe you have a child where they're never going to be the trustee of their own trust. There's always going to be a need for somebody else to manage the money. How do you want the money managed? What are the goals that you want done? Do you want them to get, an income every year? Do you want it to offset their costs if they engage in maybe doing teaching to lower income individuals? Do you want the funds to be there to help with a bar mitzvah, a wedding, starting a new business, buying a first house, whatever the case may be? Think about this. This isn't something in the trust document that the trustee or the guardian must follow, but it's your general instructions to them. And if you do have one of these, update it frequently. Things change over time. Plan once a year, maybe, April 15th, now that tax day is done, that's your tickler to yourself to update your trustee and guardian guidance. With that, I want to thank you for your time listening to this. I hope that you found it valuable. I really love practicing in this area of the law. One of the reasons that I do is because individuals are empowered to pass their values and their assets in a way that provides security, however they define security for their families. And because it's something that you're empowered to do, particularly in this time when there's so much stress and unease and uncertainty, it might be a great opportunity to do something so that you can say, all right, estate planning is done, it's checked off, I don't need to worry about it anymore. If you've got questions, first reach out to your attorney who drafted your documents. I'm sure that he or she would be delighted to speak with you. You can ask me. I'm putting this together because I really do want to support our community during this time. And this is the information that I know about, so the information that I can share to be able to provide value to people. And if there's anything else that either I or anyone else on the Porzio team can help with, please just ask us. We're all in this together, and there might be an answer to a question that can reduce the stress that you're having, a worry that you're having, or give you an action plan for how it is that you would be able to move forward. With that, I wish you the best. Thank you very much.